A major ruling was issued last night by the Ninth Circuit Court of Appeals in the case involving whether Donald Trump could federalize National Guard troops, pull those National Guard away from the governor of California, and once these troops are federalized, send them into Los Angeles, where they're currently stationed, positioned around federal buildings in Los Angeles. It was a 3-judge panel that made this very significant ruling. 2 Trump-appointed judges and 1 Biden-appointed judge, but all 3 agreed here. And it was not a good ruling, but we here at the MeidasTouch Network, we report the good, the bad, the ugly, and we got to report what actually went down. This 3-judge panel ruled against California, ruled in favor of the Trump regime, and they granted the Trump regime's motion to stay or pause the lower federal court ruling pending the appeal. And so while it's framed as a procedural move by the 3-judge panel in the Ninth Circuit Court of Appeals, pausing the ruling by a lower federal court, where that federal court, Judge Breyer, said that Donald Trump's regime violated the law under the applicable statute 10 U.S.C. 12406. And I'll describe what all of this means in a moment. Even though framed as a procedural ruling, just pausing what the district court ultimately ruled, the Ninth Circuit and analyzed whether they thought the Trump regime would ultimately prevail on their appeal on the merits in order to have the stay granted. And all 3 judges said that they believed that Donald Trump had the right to federalize National Guard troops and send those troops into LA. Now, the 3-judge panel, if there's any silver lining to be found in this order, they still found that Donald Trump did not have unfettered discretion to analyze the law however he wants, or that Trump's actions could not be reviewed by the court. The Ninth Circuit Court of Appeals found that this was a justiciable issue, that courts can review what Donald Trump did. But when this Ninth Circuit Court of Appeals reviewed Donald Trump invoking of this statute, 10 U.S.C. 12406, they said that we will give a lot of deference to the President of the United States invocation of the statute. And they said that he was okay for invoking that statute. Then when they analyzed another provision of the statute, which requires that the orders be made through a governor, which was not specifically done here, they found that the Trump regime satisfied that element. The Ninth Circuit found the Trump regime satisfied that element by issuing the order through the adjutant general, who's the leader of the National Guard in California, even going around the governor. This 3-judge panel said that the adjutant general just getting a letter from the Trump regime is sufficient for the statute that says the orders must be issued through the governor, which absolutely makes no sense to me. I want to go through the details of this so you understand what they said, even if, like me, you vehemently disagree with them. I want to take emotion out of it, and I want to share with you the facts. So beginning with the facts, I always say, let's look at the statute, right? So Donald Trump purported to invoke the statute 10 U.S.C. U.S. Code 12406. That's the name of the statute. The statute provides whenever 1, the United States or any of the commonwealths or possessions is invaded or is in danger of invasion by a foreign nation. 2, there is a rebellion or danger of a rebellion against the authority of the government of the United States. Or 3, the president is unable with the regular forces to execute the laws of the United States. The president may call into federal service members and units of the National Guard of any state in such matters as he considers necessary to repel the invasion, suppress the rebellion, or execute those laws. Orders for these purposes shall be issued through the governors of the states, or in the case of the District of Columbia, through the commanding general of the National Guard of the District of Columbia. So the lower court in California, the federal court, the district court that ruled in favor first of Governor Gavin Newsom, looked at the statute and asked, were any of these elements satisfied? And they said, and the Judge Breyer, said no. The judge said the United States had not been invaded and was not in danger of invasion by a foreign nation. So that wasn't satisfied. 2, was there a rebellion or danger of rebellion against the U.S.? The federal district court judge said no, that wasn't satisfied. 3, the president is unable with regular forces to execute the laws of the United States. The district court judge says that wasn't satisfied either. The LAPD and the LA sheriffs were doing a fine job conducting business. It wasn't like federal laws could not be executed. There was only 400 people arrested, which is like 0.003% of everybody in LA. In a city and county of millions of people, about 400 people got arrested. That's like less than when the Dodgers wins the World Series. And then on this other element right here, where the statute requires that orders for these purposes shall be issued through the governors of the states, the district court said it was never issued through Governor Gavin Newsom. So you lose, Donald Trump. So then Donald Trump goes to the Ninth Circuit Court of Appeals. That's this 3-judge panel that made this ruling. And he requests that they issue a stay or pause the district court's order, because the district court's order would have prevented or stopped the Trump regime from federalizing the National Guard. So that is where the Ninth Circuit Court of Appeals, which is the boss of the district court in the Northern District of California, which made the underlying ruling, they said that an emergency stay or a stay should issue in favor of Trump because Trump is likely to win on the merits. Now, what's their argument for how Trump would win on the merits? Well, they say under subsection 3, 10 U.S.C. 12406 subsection 3, which says the president is unable with regular forces to execute the laws of the United States. The Ninth Circuit Court of Appeals, all 3 judges, the 2 Trump and the 1 Biden appointed judge, says that you have to give a lot of deference to the president in making that determination, and that there's a sufficient factual record that because there were protests around the federal court buildings, that by federalizing the National Guard and moving them to federal court, like federal court buildings and other federal buildings, that was a sufficient use of subsection 3. And then what the Ninth Circuit Court of Appeals said is that by simply sending a letter by the Department of Defense to the Adjutant General of the National Guard of a state, that satisfies the provision where it says orders for these purposes shall be issued through the governors. In other words, the Ninth Circuit saying the governor doesn't actually have to directly be involved or coordinate. Let me just share with you the exact words of this ruling now that I summarized it so you can see what this atrocious ruling actually says. In 10 U.S.C. 12406, Congress authorized the President of the United States to, quote, call into federal service members and units of the National Guard of any state whenever one or more of 3 conditions are satisfied. In response to disturbances, and then it goes on to talk about what went down in Los Angeles, but then it goes and it says, we now grant the stay. Defendants, Trump, have made the required strong showing that they are likely to succeed on the merits of their appeal. We disagree with defendants' primary argument that the president's decision to federalize members of the California National Guard under 10 U.S.C. 12406 is completely insulated from judicial review. So pause there. That's why I said if there's any silver lining of this decision, it's that, because the Trump regime is arguing federal courts don't have any ability to review any decision by the Trump regime to do anything involving federalizing the National Guard. So here, the Ninth Circuit says, no, we get to look at it, but we think you did the right job by invoking 10 U.S.C. 12406 subsection 3, which is incomprehensible to me. So this is what they say. The Ninth Circuit says, nonetheless, we are persuaded that under long-standing precedent interpreting the statutory predecessor to Section 12406, Our review of that decision must be highly deferential, meaning we'll pretty much always agree with whatever the regime says unless it's outrageous. They go on to say, affording the president that deference, we conclude that it is likely that the president lawfully exercised his statutory authority under 12406 subsection 3, which authorizes federalization of the National Guard when the president is unable with the regular forces to execute the laws of the United States. Additionally, the Secretary of Defense's transmittal of the order to the Adjutant General of the California National Guard, who is authorized under California law to issue all orders in the name of the governor, likely satisfies the statute's procedural requirement that federalization orders be issued, quote, through the governor. So they're saying the governor doesn't actually have to be involved in it. It just has to pass through the governor's office, but the governor has no say. Whatever happened to states' rights here? And even if there were a procedural violation, that would not justify the scope of relief provided by the district court's TRO. Our conclusion that it is likely that the president's order federalizing members of the California National Guard was authorized under 12406 subsection 3 also resolves the 10th Amendment claim because the parties agree the 10th Amendment claim turns on the statutory claim. So they're basically saying that the 10th Amendment claim involving states' rights does not apply here at all if the federal government is able to properly invoke that statute. So I read for you what the statute says. And then when they apply the law, they basically say the following. They say, as defendants correctly argue, Section 12406.3 cannot plausibly read to mean that so long as some amount of execution of the laws remains possible, the statute cannot be invoked regardless of how much execution of the laws remains thwarted or how much personal danger federal personnel face during operations, or that so long as any quantum of federal law enforcement could be accomplished in the face of mob violence, the president would be unable to call up the National Guard to respond. Section 12406 does not have a prerequisite that the president be completely precluded from executing the relevant laws of the United States in order to call members of the National Guard into federal service. And then it says, under a highly deferential standard of review, defendant Trump regime presented facts to allow us to conclude that the president had a colorable basis of invoking it. They presented evidence detailed above of protesters' interference with the ability of federal officers to execute the laws leading up to the president's federalization of the National Guard on June 7th. There is evidence that the day before, protesters threw objects at ICE vehicles trying to complete a law enforcement operation, pinned down several FPS officers defending federal property by throwing concrete chunks, bottles, or liquids and other objects, and used large rolling commercial dumpsters as a battering ram in an attempt to breach the parking garage of a federal building. Plaintiffs' own submissions state that some protesters threw objects, including Molotov cocktails, and vandalized property. According to the declaration submitted by defendants, those activities significantly impeded the ability of federal officers to execute the laws. By the way, that completely contradicts what the LAPD and LA sheriffs said, which was that the protests were by and large overwhelmingly peaceful. They had everything under control and the National Guard wasn't needed. So for those reasons, I find this ruling to be completely atrocious. There was a Biden-appointed judge who agreed with the two Trump-appointed judges. Where this goes from here, I think that California is going to appeal. But ultimately, if a ruling like this is able to stand in place, you will have more federalizing of the National Guards, a complete usurpation of states' rights in totality by the federal government, and the National Guard will basically become, under a very, to use their term, deferential standard, just completely a tool of the federal government. To me, it's probably one of the worst judicial rulings I've ever read. That's why I wanted to read it to you so you can see it for, yourself. But it's one of those rulings where it's like, The statute's pretty clear what's required. And it seems that these federal judges went completely out of their way to find some excuse to basically give dictatorial power over. So that's what the ruling is. We'll see what the next move is from California. If they're going to appeal to what's called an en banc panel before the full Ninth Circuit, I think we're going to see that happen. And then I think Governor Newsom brings this to the Supreme Court. And I think that there's a serious states' rights argument that then gets made there under the 10th Amendment. I think they have to bolster their 10th Amendment argument as well. We'll keep you posted every step of the way. The good, the bad, the ugly. I got to report it all here. That's what we do here on the MeidasTouch Network. We report it all. Hit subscribe. Let's get to 5 million subscribers.
New Meidas merch drop. Check out the latest pro-democracy sticker packs, t-shirts, hats, sweatshirts, and more. All at store.meidastouch.com.